I think we're going to get started, at least our introduction part of it, as we are still waiting for a few more people to join us. But I'd like to say good afternoon and thank you for joining us. My name is Janine Paterno, and I am with Belmont Village of Assisted Living of Glenview. I am joined by my colleagues, Erin Blair, who's from our community in Geneva Road, Lauren Hollish, who's from our community in Lincoln Park, Susan Casanda, who's from our community in Buffalo Grove, and Shalana Thomas, who's from our community in Oak Park. We are joined today, Belmont Village is sponsoring this along with Suncrest Hospital, Ryan Gaza, and a Rosa Live Home, which includes Life Care Innovations, Life Care Guardianship, and Partners in Senior Care. They are also, Lauren Sherman is also with Rosa, and she is our presenter today. A little bit about Belmont Village. I just wanted to tell you we are an assisted living community with a memory care component. We do have 3 levels of memory care. One of our programs is called Circle of Friends, and that is for mid to mild memory care, and that has won the Argentum Award. And so for many people, they no longer thrive in assisted living, but they do not need secured component of memory care. The Circle of Friends has been developed for that particular resident. I ask that if anyone has any interest in it, please get in touch with the appropriate Belmont, and any of my colleagues or myself, we would help you and talk to you about our programming and our community. Of course, we have 24-hour nurses and therapy, and we really, really hope when a resident moves in, our wish is that this is their last home. That is what our programming does for our residents, and they could live from assisted living through the end of life. Part of that is having hospice come in, and Ryan will talk to you about what hospice can offer in a community or in a home. So I thank you for joining this program today. We are very, very fortunate to have Lauren Sherman here talking on such an important guardianship, and we really, really think that she is here. Thank her. So Ryan, if you want to go ahead and talk about Suncrest, please do.
Sure. Thanks, Janine, and good afternoon to everybody. Good to be with all of you on this sunny day. I'm Ryan. I'm the Guza Area Director at Suncrest Hospice, where we're committed to providing the highest quality of care and customer service to our patients, families, and referring sources, actively covering Lake, Cook, Will, DuPage, and McHenry counties. And to Janine's point, the hospice philosophy is all about quality of life and making sure our loved one, your patients and residents remain in their homes through end of life.
Okay, thank you, Ryan. Hi, everyone. I'm Claudia Cook with the Rosa, which includes Live Home, Life Care Innovations, Life Care Guardianship, and Partners in Senior Care. A few quick things about us. We are now the largest integrated care management and home care agency in Chicago and the country. We're serving all of the Collier counties and Cook County. Let's see, what it means to be the integrated care management is that for our caregiving services, we lead with our care manager. You're getting a very comprehensive assessment, and the care manager will oversee the caregiver, communicate with the family, communicate with the whole care team, and also trains them one-on-one as necessary. The second thing it means is that our care managers, we have a unique model of care management. We've got a team approach where it's kind of like having an attorney and a paralegal. So we have range for our care management fees, and you're just getting a lot more eyes and perspectives on care. We're providing guardianship, and we also act as powers of attorney for property and health. Okay, let's see, Janine, the next thing I'm going to say is, we'll be sponsoring the CEU certificates. So what's going to happen with that is After this call or after this webinar, when I get the list of all the attendees, I will email you all from my from my Live Home account, Claudia Cook. You'll receive a link to the evaluation. If for some reason you can't open it, please reach out to me. I'm going to put my contact information in the chat. So make sure to let me know if you can't access it. Then after that, ideally, if you've completed today, I will send you the CEU certificate. Let's see, so that any questions you guys can just put in the chat. I'll be monitoring that today and also monitoring it for our Q&A session with Lauren afterwards. Lauren also said that she'll be able to stay on if we have additional questions. So let me just introduce Lauren Sherman. She's our the area director of Rosa. She is a licensed clinical social worker and is only one of 6 people in Illinois who holds the National Master Guardian distinction from the Center for Guardianship Certification. She has over 15 years experience in guardianship and is a great resource. We're lucky to have her in the Chicago area. Lauren? And if we could all, everyone else turn off their mics and videos.
Good afternoon, everyone. I'm so excited to have everyone join us. Claudia, can you just confirm you can see my screen now?
Yes.
Okay, great. So as Claudia was saying, guardianship is an area that I have practiced in for a number of years, and it's something that I really, I hold dear to my heart. It's, we've worked with a lot of clients through guardianship. One thing I always do caution, though, when doing this is that guardianship really should always be a last resort. And there's a number of reasons for that. And while we go through the presentation, you'll see some things about some of the basic rights that are taken away when somebody's under guardianship and some of the pitfalls of having a guardian appointed. So hopefully this will give you guys some good basic knowledge about guardianship and the process, and what some alternatives are, because if you can have alternatives, that's always really the best option. So just quickly to go through the objectives, we're going to talk about in a perfect world, what planning looks like, discuss some of the risks when a decision maker fails. We'll talk about what guardianship is and what that process looks like. And then we're also going to talk about how a guardian comes about to making decisions for individuals that they may be in place for. So one thing that we try to do with all of our clients, and as Claudia and Janine were saying, you know, we're a care management company, so we get hired to work with adults who either have some age-related frailties or maybe they have some other type of disability that really renders them needing assistance with managing some of their day-to-day tasks. And so one thing we always try to do with our clients who are still competent and able to do some planning is really encourage them to plan as much as they can. If you can avoid guardianship, you always want to do it, because ultimately in a guardianship, the decisions are really kind of taken out of your hands. So just to go through a couple things that can be good planning tools for guardianship: advanced directives, so simple powers of attorney, those types of things are good alternatives. Trusts are a way to help protect assets and designate somebody to manage any of the assets that might be held within that trust. Obviously, creating wills is a wonderful idea. You know, in all of this, though, it has to be working in that the people that you choose to maybe make decisions on your behalf have to be available and willing and appropriate to step in and make those decisions for you. So some alternatives to guardianship. This is always an interesting thing that I ask people. And, you know, when I first went into this field, in my mind, if you had a situation where there was a power of attorney and a guardian, when I thought about it, in my mind, it always made sense to me that a guardian actually had more legal authority than a power of attorney. And the reality actually is that's not true. When you think about it, it really makes sense. As a guardian or as a power of attorney or any type of surrogate decision maker, your goal is not to make decisions how you think they should be made and in line with what your decision-making processes are. Your goal is to really step in and make decisions how you think that person would be making them if they were still able to. And so because of that, a power of attorney or a trust, those are all decisions that the individual in question actually did make on their own while they were still competent and of sound mind. So those documents actually hold more weight than a court-appointed guardianship. You're not going to have a lot of circumstances where you have both, because one of the first things that they look at when you're considering guardianship is, are there advance directives? Is there a designated healthcare power of attorney or a power of attorney for property or trustee? And if there is, you need to be able to show why that document doesn't work, whether it be that the agents don't want to act, or sometimes people name agents that may have predeceased them and are not available, or maybe in circumstances, unfortunately, those agents may not be acting in the best interest of the individual. And in those cases, the courts will remove them if there's not some type of other resignation ahead of that. So powers of attorney and trust are great alternatives to guardianship. The other thing that is allowed is there is the Surrogate Act, which allows people, if they really, this is mostly done in acute care settings where somebody may have an accident and they go in and they're not, they may be in a coma or something has happened that has prevented them from being able to make decisions in that very moment. And so there is a Surrogate Act that allows for two doctors to certify that somebody is not decisional at the time, and it allows them to designate another person. And it goes through a list of hierarchy. A spouse is always going to be the first option, and if there isn't a spouse, then it goes down the line to adult children, parents, siblings, and it even goes all the way down to like friends. You don't see a lot of doctors that are going to certify somebody and designate a friend as their surrogate decision maker at that time, but it does happen from time to time. One of the pitfalls of the Surrogate Act, though, is it's really great for acute medical needs. When somebody's in the hospital and there needs to be decisions regarding different treatment options, that Surrogate Act works really well. It's not really a great long-term plan, especially for somebody who is going to have care needs on an ongoing basis. It will allow somebody to make decisions regarding their care. However, it doesn't give any ability to access finances. And so if somebody needs to go to some type of facility or receive some type of rehab after the hospitalization, it doesn't allow them to access their finances to be able to pay for that care. So it's not really a great long-term fix. So just a couple really brief definitions about guardianship. It's someone who's entrusted by law for the care of another person or their estate, somebody who guards or protects, and then just really the most general and applicable to us is it's a substitute decision maker for another individual. Because this is a legal process, ultimately somebody in terms of a guardianship is considered to be competent until a court adjudicates them as being incompetent. And so competency is going to be something, there's lots of different thresholds to competency. It is used in lots of different settings and environments, but in terms of a guardianship, again, because it's a legal process, somebody is considered to be competent for guardianship until the court deems them incompetent. So it actually states in our statute what some of the causes of disability can be that might lead to a guardianship. The thing that you most commonly are going to see is mental deterioration, normal age-related issues, dementia, Alzheimer's types things. That makes up a good portion of the guardianships, I would say. Physical incapacity could be another reason, but keep in mind it's just a physical incapacity. If I am in an accident and I become a double amputee, that doesn't mean that I'm not able to make my decisions regarding my care or my finances. It has to be some type of physical incapacity that renders the person unable to either make sound decisions, so it's caused some cognitive impairments, or unable to communicate those decisions in any way. There are some conditions, unfortunately, like things like MS, where even very late in the progression, their mind may be pretty good, but they lose the ability to communicate in any way, whether it be by speaking, grunting, eye blinks, writing, anything that you can do to communicate. Once they get to that point where they can't communicate their decisions, even though their mind may be working fairly well, unfortunately, there does need to be another decision maker. Mental illness is another cause that could lead to guardianship. When we talk about mental illness, these are not just, routine kind of depression issues. These are very severe, pervasive, chronic disabilities like schizophrenia, bipolar disorder. They're conditions that are so severe that they really are not allowing the individual to manage their day-to-day affairs well. Developmental disability or intellectual disability is certainly another thing that you see a lot of. One thing to keep in mind, we're pretty good at, for school age or children, obviously a parent is the legal guardian of that individual while they're a child. But once they do reach the age of majority, if there needs to be a permanent decision maker put in place, you do need to go through the guardianship process and have a guardian appointed for them, for that parent to continue to make legal decisions for them. Addictions is another thing we see sometimes. These are probably some of the more complicated cases, but these are also some of the cases where we have actually been involved, where somebody may have had a very, very severe chronic addiction issue, in and out of rehab, just not functioning well, may have run into financial issues, may have run into other legal issues like, multiple DUIs or being arrested for other behavior-related issues. We've actually seen some of these cases where we've become the guardian of, and as we get them through their treatment and see some longevity and some stability in their condition, we've been able to restore some of them because the addiction may not have led to kind of a permanent cognitive issue that you might see with some of the more chronic addiction issues. Brain injury is certainly another issue that we do see. You see a lot of accidents where there may have been some type of traumatic brain injury, and this is when you see some of the younger people that may have to go through the guardianship process. Self-neglect and hoarding is something we used to see quite a bit of when there was when they started to include self-neglect as part of the elder abuse investigation several years ago. We started to see a bit of an uptick in these cases. There's still quite a few, but we're not seeing quite as many as we used to. So what are the areas of decision making where a guardian actually takes over? So a guardian of person, and we're going to go over what the different distinctions are between the different types of guardianship, but the guardian of person is really the one that's responsible for their care and their person. So they would be involved in living conditions, medical care, any type of educational or vocational services that they might have, any ancillary professional services that you might need to bring in. And then also, if you become guardian of somebody who has dependent minor dependents, you actually become responsible for them as well. And so that's something you need to be mindful of if you ever are working with somebody and they have children that they are the sole, that are dependent solely on them. You need to make sure that there are arrangements made for those children, or know that you're going to also be responsible for the care of them as well. Managing the finances is going to be the responsibility of the guardian of estate, and we'll go through in a little more detail what that means. There are a lot of things you may not think of. So we talked about that guardianship should be a last resort, and here's one of the big reasons. There are a lot of personal rights that can be removed if you are under guardianship. Voting. In Illinois, you are allowed to vote. It is the responsibility of the guardian really to make sure that an individual understands that process and understands what they're doing. There are many jurisdictions, though, where if you go under guardianship, you can no longer vote. And obviously, this is a hot topic right now, and so that's one of the very basic personal rights that is taken away. You can't drive or travel. There are some ways around driving, but if you are under a full or what's called a plenary guardianship, you are really not able to retain a driver's license any longer. We'll talk about some ways around that, but traveling. We always make sure if we have a client that is going, if they're traveling locally, certainly that's typically not an issue, but if they want to go on vacations outside of the state or outside of the country, those are things we always want to work with the courts and make sure we get approval for that process and that everything is set up for them for when they're going on that. You can't enter into any contracts or break any contracts, so you can't hire any type of services that you would normally do. So this would include medical services, this would include things like landscaping services for your house. You no longer, if you are under a full guardianship, retain the right to execute any types of contracts. Working. You can work when you're under guardianship, but this is something that is monitored by the courts, and it has to be done with the court's approval. If you have a FOID card, once a guardianship is established, the courts do report that to the Secretary of State, as well as some other entities, and so your FOID card typically would be revoked. And then you also don't have the ability to get married after you've become subject to a guardianship. And you also typically don't have the ability to get divorced. That's something they're looking at now kind of on a case-by-case basis. The general rule is that you can't start a guardianship proceeding after a guardianship, you can't start a divorce proceeding after a guardianship proceeding has been initiated. They are making some exceptions, but that's on a one-off basis. But in general, you cannot start divorce proceedings after guardianship. So there are multiple different types of guardianship, and I have had the opportunity to serve on the board of the National Guardianship Association, and so I've been able to talk to people around the country about what their probate or guardianship systems are like. And I will tell you, we are in Illinois, we're really pretty sophisticated in terms of how we use our guardianships and the different types of guardianships. We're really very creative about making sure we're using the least restrictive types of guardianship. And so that's really good to see because, you know, obviously if you are taking away somebody's rights, you want to be as mindful as possible of leaving as much independence as you can. So a guardian, we're going to go through each of these. Within the guardianship, there are two sides. There's going to be a guardian of person and a guardian of estate, and I think the next slides will talk about what each of those sides do. But there's also different types of guardianship within a guardian of person or a guardian of estate. And so just really quickly, there are things called temporary guardianships, and these are used in emergency situations. There are lots of different things that will qualify for an emergency. They are pretty strict these days. It used to be that, people would go in and say, I've got an emergency, and the judge would hear it. But it caused the court calls, I think, to get very, very busy. And so now you do actually have to show proof that there is some urgent need. So it could be something like urgent medical care. Life-sustaining treatment is going to be done regardless. But there might be some types of other medical care that the doctors that are not considered life-sustaining, and there needs to be consent for the treatment. And in not doing it pretty soon could lead to some difficulties in the rehabilitation. So urgent medical care, urgent financial situations. We've had clients that have been subject to foreclosure on properties, and unfortunately it's gotten up until kind of the very last date for them. And so we've been able to go in and establish some emergency guardianships for emergency temporary guardianships for guardian of estate to kind of halt that process and let them know somebody is being put in place, and they'll give you a little extra time to get things sorted out. Placement. We see this happen a lot where an individual goes into a hospital, clearly is not decisional, but there's nobody else that is in place to make decisions, and they need to get some aftercare at some type of, or rehab at some type of facility. And it's difficult for the hospital sometimes to discharge them without somebody that can actually execute the contracts for the facility. So they sometimes get, the patients may get stuck there. That is something that the courts will see as an emergency and get you in quicker to get that guardianship established. So plenary guardianship we'll talk about first. That is really kind of the full guardianship. Oh, one thing just about temporaries. They cannot last longer than 60 days. So any order that creates a temporary guardianship is good for a 60-day period. They will extend those sometimes, and they'll go in on day 55 or 59 and enter a new order for temporary guardianship, extending it an additional 60 days because maybe your investigation hasn't been completed and you need some additional time to figure out the long-term plan. They will allow that, but typically not more than, a couple times. At that point, they really want you to figure out the long-term permanent plan. So in terms of the long-term guardianship, plenary guardianship is when somebody lacks the ability to really make all decisions regarding their personal or financial affairs. And so we will discuss a little bit. There is a physician's report that is required for guardianship. On that report, they actually ask the doctor, is the individual totally or partially incapable of making decisions? And so if the doctor documents that they're totally incapable, they will likely end up in a plenary guardianship. And so in this type of guardianship, basically everything, all of the decision-making rights are taken away from the individual and given to the guardian, except there might be some specific things that they put in a court order that they allow the individual to manage on their own. So some examples, there might be a plenary guardian of estate where all of the client's assets are going to be managed by that guardian of estate, but they may put in a court order that allows the individual to have a small checking account, maybe not to exceed $500 or something. So everything is taken away except the things that are left in place by court order. So a limited guardianship is kind of the opposite. In a limited guardianship, the doctor has indicated that somebody is partially incapable of managing their affairs. And then they do ask the doctor to expand on that and discuss what things can they do and what can't they do. And they cater that limited guardianship then towards the individual needs. So in a limited guardianship, all of the individual retains all of their rights, except the specific things that are taken out and assigned to the guardian to manage. So it's kind of the opposite of a plenary. These are really useful tools. and we use these a lot with clients. More often, it's going to be maybe some of our younger clients that are not having dementia or Alzheimer's, because those are obvious, many of those are progressive in nature and you're not going to see any improvement. But some of our younger clients who have maybe a chronic mental illness, and when they have periods of stability and compliance with their treatment plan, they may be very lucid and manage very well. And so with these limited guardianships, it gives you the ability to let them have as much independence as possible, but still be in place so that if they have a hiccup or if things start to decline again, you're already in place to help kind of get things back on track. The other thing about a limited guardianship, and again, this is helpful for our younger clients, we talked about a driver's license. If you are under a plenary guardianship, you should not be retaining a driver's license, but you can with a limited guardianship. That's not automatically revoked under a limited guardianship. So again, some of our younger clients who have really good periods of stability, it's important for them to be able to drive. And as the guardian, it's your responsibility to make sure that they are still doing that safely, and if there's a question, then you have different evaluations done or go back to the court and report that something has changed. So the guardian of person is responsible for managing the personal affairs of the individual. So you as a guardian of person would be responsible for really providing a plan of care to the court and basically telling them what the plan is for the individual. That would include things like living situation, any educational services, religious rights, parental rights, vocational services, as well as giving any medical consent. Sexual rights is also something that is always, this is always a bit of a difficult topic, especially when we're dealing with some of our clients that have some age-related dementias or cognitive impairments. As a guardian, we do not have the right to stop somebody from engaging in sexual activity, but we take some precautions, like talking to the facility, talking to the doctors, making sure there's not a reason that they shouldn't be engaging, and also asking for the facility maybe to talk to the other individual's family and make sure they're aware of what's going on. Guardian of estate is managing the finances or the estate-related issues. So this would include locating the assets. So this can be a really difficult process to do. One of the first things that I think is really important to do when you become guardian of estate is to have the individual's mail forwarded, because otherwise, you might not be receiving bank statements. Tax time is a really good time to start to figure out what the assets are, because you'll start to get all of the year-end tax statements. Once you've located the assets, you need to collect or marshal them. As a guardian of estate, you have a responsibility also to evaluate and look at what somebody's entitlements and benefits may be and manage those programs, and also look to see if people are not receiving benefits that they're eligible for that could help preserve their assets or help get them additional services or coverages. You really have a responsibility to maximize any type of benefits that they should be getting. You do all of their ongoing bill paying, maintaining their assets. If you have a client that has fairly significant assets, you want to make sure that you're engaging financial planners or people that will help you to make sure that the client's assets are well run. Defending any type of lawsuits that they might have, or divorces. So we said that clients cannot initiate divorce proceedings after a guardianship proceeding has been started. We've had several clients come to us where the divorce proceeding was actually initiated first. And through that divorce proceeding, either the client's attorney or sometimes the judge even in the divorce proceedings realizes that the individual just is really not understanding the process and is not able to look out for their best interest. And so they may recommend the initiation of guardianship proceeding. If that's happened, as a guardian of estate, you're responsible for seeing that divorce proceeding through, or any other type of lawsuits. We've had clients that have been different types of medical practitioners, and they may have practiced a little too long, unfortunately, and maybe have had some lawsuits that have been filed against them. As the guardian of estate, you work with their insurance to make sure that those lawsuits are defended, and then go through the process of what's needed to prevent any further issues. So we've had clients that have had medical licenses, and we've gone through the process of either getting that license put on hold or revoked, or something like that, to make sure that there's no further risk. And then managing and maintaining real estate. This can be, especially in areas that have cold winters, you want to make sure you're really doing your due diligence. We have a lot of clients who may not be able to continue to live in their home for some reason, and maybe that home is going to be maintained and not necessarily sold. You want to do things like make sure the house is winterized. That's something we're doing for all of our clients right now. You never want to end up in a situation where you haven't kept the heat on or winterized it, and you end up with broken pipes that have caused significant damage. So you got to just be mindful of that real estate and make sure you're doing everything to protect it, as well as making sure that it's appropriately insured, all the contents are insured, and that somebody is routinely going in to look at it. You don't want to let it sit for 3, 4, 5 months and then go in and find out there's been an issue. So we're going to talk a little bit about the guardianship process and what it entails. The first thing that needs to happen really is somebody needs to identify that there's a need for a guardianship. And that person can be anybody. It can be a family member. It can be, many times it's a trust officer working or banker working with the individual, or sometimes their attorney might identify it. Sometimes it's a facility or a hospital, or it could just be a friend. So anybody really can be the one that identifies that. And then figuring out who's going to actually execute a petition for guardianship. And so basically the petitioner is it's the person that says, I believe a guardian needs to be appointed. Here's who I'm nominating. And they sign that document. They may or may not be involved on an ongoing basis. Once the petition is filed, there's a scheduling of an initial court date. Emergencies are handled much quicker, and so a lot of emergency cases, you might file the petition and then, pretty quickly get a court hearing like that day or the next day. A normal routine guardianship, if you're filing for a plenary or limited guardianship, usually you're several weeks out. So it may be, 3 to 5 weeks until that initial court date is scheduled. Obviously, right now with COVID, this is all court proceedings are being handled remotely. And so it's really kind of dependent on what the schedules are of the court. So for that initial court date, there's a couple things that you need to make that are going to happen or you need to have ahead of time. We talked about this physician's report. Many people generically refer to that report as a CCP 211. CCP refers to Cook County probate, so that's actually the Cook County form, but it's that term is used generically, I would say, for a lot of areas, but it's going to be called like the physician's report or physician's affidavit or physician's evaluation for guardianship. And they all are slightly different, but generally ask the same questions. They want to know what's the actual condition that is causing the disability. How does that condition really affect the day-to-day functioning? And are they partially or totally incapable of managing their personal and/or financial affairs. And they also will ask things like, what is the best living arrangements for an individual, and what are the things that maybe the individual can or can't do but on their own. So that's really important to have that ahead of time. Another thing to keep in mind is that physician report has to be fairly up to date. It has to be generally, can't be dated more than 60 days prior to the filing of the petition for guardianship. And it also does ask the physician, you know, what date did you see the individual? So it's not somebody that maybe a primary care physician that they saw them 6 months ago and they're filling it out now. They want the doctors to have seen them within that 60-day period. Service to client is also going to happen. Again, these are legal proceedings, so just like in any other lawsuit, the individual has to be served, and that's either done by the sheriff's department, or sometimes you have a special process server that delivers those documents. Sometimes somebody else might receive the service on behalf of the individual. So if they are represented by an attorney, I've sometimes seen that the courts have allowed that attorney to receive the service for the client. And then at that initial court date, one thing that is likely going to happen is going to be the appointment of a guardian ad litem. And so those of you that work in hospitals or facilities and maybe have had clients that have, or residents that have had guardianships filed on them, you might have seen a guardian ad litem come in. So a guardian ad litem is generally, it's an attorney, and it's really kind of the judge's eyes and ears. Their job is to really look out for the best interest of the person in question, but they go out and see the individual, whether it be in the house or in the hospital or in some type of residential facility. They will go out and visit them. And they will also talk to staff there, or talk to the doctors, or talk to family members. They will also talk to the person in question and really interview them as much as they can to try and ascertain what's going on. And is the person, you know, do they really think a guardianship is needed? Attorneys are not medical professionals, so they're not necessarily basing it on medical information. You know, they will formulate an opinion based on what they've been able to gather during that interview process and collection of data. And they also are going to find out if the individual in question is in agreement with the guardianship, or if they are contesting the guardianship, or maybe they're in agreement with the guardianship, but they're not in agreement with the person or entity that's nominated to serve as their guardian. And so maybe there can be some sort of agreement to have the guardianship, but substitute the nominated party with somebody else. And then once they've gathered all that information, the GAL comes back to the court and reports to the court on what they've found and what their recommendation is, and whether or not they believe a guardian needs to be appointed. And they go through, you know, what the individual's agreement level is with each of the items pertaining to the guardianship. So it's important that that guardian ad litem actually does talk to the individual, because if the individual is contesting the guardianship, a judge cannot just go and appoint somebody and say, I don't care that they're not in agreement, we're still going to appoint the person. It has to end up going through kind of a trial process to be able for the courts to actually appoint someone. So a trial, just like any other type of law proceeding, where there would be witnesses, there would be evidence, each side would put on their case, and then a judge could make a decision and a ruling on what they believe needs to happen. So when you're looking at having a guardian appointed, family or friends is always going to be the first option. These are the people that know them best. These are the people that have been involved with them. These are likely the people that individuals are most comfortable with serving. So if there is family, members, either, immediate family members or maybe, more distant relatives by blood or marriage, or even friends that are willing to serve. Those are always going to be where you're going to look to first. If no one is available, there are some other options. Excuse me. We're unique in Illinois where we really have two kind of public guardianship programs. There is the Office of State Guardian, which is a statewide agency, and this is really, it's almost like a public aid program for guardianship. It's for people whose estates are valued at less than $25,000, and they are state employees. They, they have offices throughout the state, and they will take on those guardianships as they get appointed. There's also the public guardian, and these are for individuals that have larger estates, so typically over $25,000 in assets. And the public guardian is a little different. These are they're county specific, so each county has a separately appointed public guardian. In Cook County, the Office of Public Guardian it's actually the largest public guardianship program in the country, I believe, at this point. And it is a huge, wonderful kind of social services, legal organization where, they have case managers, they have social workers, they have nurses, they have accountants, they have attorneys that work in the public guardian's office. And so they are an option for people that have more resources and are not eligible for the Office of State Guardian. In other counties other than Cook County, it's actually typically an attorney who's in private practice and they accept the public guardianship appointment as a part of their practice. And so, they may have 25% of their practice is public guardianship appointments. And they personally are actually the named public guardian for those individuals. For people who don't have a friend or family available and for one reason or another, either the public programs are not appropriate or they just have an aversion for some reason to the public programs, there are some private guardianship options. There are lots of private practitioners, care managers that practice in guardianship and are an option. And there's also the ability for a not-for-profit entity to serve as a guardian. And so like us, Life Care Guardianship, that's a not-for-profit entity. And so we can have our agency actually appointed as guardian. And there are lots of other wonderful companies in the Chicago area that practice in this area as well. So we're going to talk quickly about decision-making process, and then we'll leave some time for questions. I said in the beginning that as a guardian, you don't go in and make decisions based on what you would do if you were in that circumstance. You're supposed to be making decisions how you think the individual would make them. And so there are a couple steps that you go through. The first thing that you want to look at is, does the individual have decisional capacity, and can they make informed consent? So people will, when you think about this, and if somebody's had a guardian appointed, your tendency would be to think, well, they've been adjudicated as disabled, so they really don't have decisional capacity. And that very well may be. But there may be some circumstances, for example, some of the individuals who maybe are in a limited guardianship where their competency may waver a little bit. So during periods where they're very lucid and independent, they may have more decisional capacity at that point. And if they do, you want them to be involved in that decision making. The other thing is, just because someone is not decisional and really lacks the decision to make proper informed consent, they still do have the ability to express their wishes. And so you want to talk with them about their wishes. There may be circumstances where their wishes just are not safe and viable options, and that's okay, but you certainly want to still talk to them about their wishes and involve them in the decision making as much as you can. If somebody doesn't have decisional capacity, doesn't have the ability to to express their wishes, really. At that point, you're going to go to trying to use what's called substituted judgment. And just like it sounds like, this is where you, as the guardian, substitute in for them. And you would want to make decisions as you think the individual would make them if they were still able to. And so this sometimes involves some research and investigation into what they might have done. There are decisions, some bigger decisions like, you know, getting ventilator care or having feeding tubes. Some of these things are issues that they may have discussed with family members, or they may have discussed with their medical providers or friends. I know my mother has discussed this with me in the past, and so I do know what her wishes would be in certain circumstances, but as much as you can, you want to talk to those people and find out and say, hey, did they ever talk to you about this? Or what do you think they might do in this circumstance? There may also be some documents that they've executed. So if they've executed a living will, you definitely want to be looking at that, or a DNR. There also might be some previously executed powers of attorney. And even if those powers of attorney are not active any longer, they may have checked one of the boxes that talks about end-of-life care. And you want to make sure you're looking at that and weighing in with that. So we talked about that. There are unfortunately going to be circumstances, There are definitely going to be circumstances where there's no family or friends or anybody who can give you any information, and the individual really just lacks any ability to have a meaningful conversation about what decisions need to be made. And in those circumstances, the guardian is really going to look at using the best interest principle. And this is where they make informed decision. They look at all of the options available. They look at the consequences and benefits of the options, and then they look at what they believe is in the best interest of the individual, weighing all those risks and consequences and alternatives. Throughout all of this, you always want to be looking for the least restrictive alternative, and look at all of the options. And this is not only just for medical decisions you're making, but things like living arrangements, even the guardianship. When you're looking at what type of guardianship, you want to make sure you're looking at the least restrictive alternative so that you are maximizing their independence and autonomy as much as possible, while still, of course, meeting their needs and making sure that they're safe and protected. So there are some things that a guardian cannot do, and this is just a short hit list, but as the guardian, you cannot just make the decision and move somebody from their home to a facility, or even from a facility to their home. There's a little more leeway in that, but if you're going to a more restrictive setting, you really need to go into the court and get approval for that placement ahead of time. There are going to be times when we've had clients that have had an accident or something, gone in, had medical care at a hospital, and have needed a short-term rehab placement for physical therapy or something in a skilled nursing facility. Those are allowable things. It's a short-term thing. We're looking at really the permanent placements or permanent moves. So those are things you definitely want to go in and get the court approval, provide them all the evidence of why you think this is needed, and get their permission to do that. A guardian cannot,
we only have like 3 more minutes. And I know you said you'd be able to stay on to answer some of the Q&A questions. Just want to put that out.
This is my last slide, so we will be done. The guardian cannot override the mental health code, which means that a guardian cannot, just like for anybody else, you cannot force hospitalization for psychiatric reasons, or psychotropic medication administration, or ECT, or any other type of psychiatric care cannot be forced against the person's will. You would need to go through the proper mental health court, and that is needed for all of those things to be in place. Withdrawing medical care. You do have the ability, actually, as a guardian to withdraw medical care. However, this is something I always caution people. It's a good idea to go into court if you're looking to take somebody off of ventilator care or something like that, especially if there are family members. And if people are not agreeing, you absolutely want to go into court and get court approval to do that. Invasive types of medical procedures are not allowed without court approval. And experimental procedures, different types of studies or alternative treatments that are not really mainstream, you want to go in and get the court's approval for all of that as well. Claudia, 1 minute left.
Wonderful.
So
Thank
I
you.
will.
Oh, go on.
I'm just looking to see what the questions are. Do you have questions, Claudia?
So yeah, there's a few questions there, but I think for those who don't want to stay on for the questions, let's just quickly, Janine, you wanted to say something about the baskets?
Yes, I just wanted to thank everyone quickly who joined us today. A special thank you to Lauren. It was an amazing presentation. Bravo. The education we received today was amazing, Lauren. Thank you. I also wanted to thank Suncrest Hospice and all my colleagues at Belmont Village and Rosa for making this possible today. A real quick note for those of you who have signed up to get your gift baskets at the particular Belmont, please remember they will be picked up between 4 and 6 today. We do thank everyone for joining us. And if anybody wants to, shoot us an email, let us know some other subjects you'd be interested in. We will be moving forward with these type of webinars. And again, we thank you. And Lauren will answer your questions. Thank you very much, Lauren.
Thank you, Janine. I am typing for the CEU certificates, I'm typing my email and my phone number in case you, some reason, don't get it. All right, so if any of you want to hop off right now, we want to, we've taken the 1 hour of your time. Thank you very much. Others, if you'd like to stay on for the Q&A, we'll get started with that portion, starting at the top. Lauren, can you see the Q&A or do you want me to read that to you?
I can see it.
We've got 6 good questions.
It's a basic process for obtaining guardianship over an adult child different than obtaining guardianship over one's parents. So we do not practice in guardianship for minors, but essentially, a parent is going to be the legal guardian automatically of a minor. If for some reason a parent is not available to be caring for the individual, then yes, it does need to go through the legal process, and that process is going to be very similar, although I think the minors courts handle things slightly differently, but you still would need to go through most of the basic process. There wouldn't necessarily be a medical need for it because you're basing it on the individual being a minor. But everything else should be similar. They would still have a guardian ad litem appointed in most cases and that type of thing. How many attempts or research should be done before pursuing guardianship for patients, such as Googling possible family members? I mean, you want to do as much due diligence as you can to identify any family members, but I will tell you there have been many circumstances where maybe a facility or a hospital has looked for family members and they don't have the ability to spend 10, 15 days doing that. And so there might be guardianship proceedings started, and as the appointed temporary or plenary guardian, part of your job also would be to find out if there are family members that are involved. And in those circumstances, you would actually maybe go back to the court and say, hey, we were appointed guardian, but there's a better alternative to us. And so you might either have the guardianship dissolved because maybe you've uncovered that there's power of attorneys, like a family member that just somehow didn't know what was happening and they're appropriate and able to serve now. Or maybe there's another family member that, again, didn't know what was happening and they're willing to serve as a guardian, and so you might transfer that guardianship to them. I'm a social service director in a SNF and have had guardians unwilling to sign a DNR. Why do guardians not want to sign a DNR when residence is declining? So there might be a number of reasons. They are about 5-6 years ago, many of the courts were actually wanting guardians to come in and get court approval to execute DNRs. Now there's a little more leeway and they are allowing guardians to do that because by statute you do have the ability to. However, I will tell you, we've been involved in circumstances where we have felt the DNR is appropriate, but there are family members that are adamantly against it, or maybe the individual, even if they, have some type of cognitive impairment, they may still be able to communicate with you that they are really against it. In those cases, we would typically go into court and present the information to the court and ask for their guidance on what to do. But not all guardians will do that. They just may make the choice to not execute it. Are there any specific medical team members that can petition? I'm assuming this question is asking, can a medical provider actually be the petitioner? I've not seen that happen because, most typically they are not going to want to have to be involved in that guardianship process. We have seen, maybe facility employees, like maybe the social service director or the administrator or the director of case management at a hospital. Sometimes they have actually been the petitioner, but I've never seen a doctor, if that's what you're asking, or a nurse be the petitioner. If a doctor office staff cannot locate anyone for a patient who has no legal capacity, what would be the action steps to establishing guardianship for the petition? Reporting APS generally does not do much. So would it be appropriate to report the situation to the Office of State or Public Guardian? So I would say if that doctor's office is maybe aware that, and most times they're not going to know this, but if they're aware that that client has an attorney, I would just say it might be in your best interest to just place a quick call to them and see if they know of anybody. But otherwise, yes, you can definitely report it to the Office of Public Guardian or Office of State Guardian. What I will tell you, I mean, they're both wonderful organizations. You can imagine, though, they're just overburdened, and so they may be a little slow to respond, just kind of as a heads up. Thank you, Lauren. I'm wondering if a group of people can be the guardian, such as children or siblings. So that brings up a really good point. This is something that both for agents under a power of attorney and guardianship, we don't encourage that people have co-guardians or co-powers of attorney, because if those people don't agree, you end up in the courts regardless. So what we always think is a better option is to name one person, and then, for a power of attorney, name maybe the other person as a successor. In the guardianship, there's not a successor until there comes a time when the primary is not serving, but we would not recommend naming co-guardians. It's a bit of a recipe for disaster, I would say.
Lauren, I've got something from Mary Gale this is in the chat, pertaining to different guardianships. If apply for emergency guardianship, does it expedite process moving into plenary guardianship?
not necessarily. What I will say is you cannot just go and file only an emergency petition for temporary guardianship. You have to file a petition for plenary or limited guardianship at the same time. What it will do is it will allow that temporary guardian to investigate things and determine maybe a little quicker if the temporary guardian or if a plenary guardianship is needed, because they will have the ability to look at finances, they'll have the ability to communicate with providers, request medical records. So it helps a little in that process. It doesn't make it quicker though, unfortunately.
Okay, thank you. The next question is, let's see, how do you become a national certified guardian and what are the benefits of having the certification?
So Illinois is not a state that requires certification. There are several states or even jurisdictions within states that do require, if it is a non-family member or friend, that they be certified or credentialed to serve as guardian. The process is managed through the Center for Guardianship Certification. They're the entity that does that certification. But I mean, the benefits are, I would say that it just shows that you've got some knowledge base and experience to appropriately serve as a guardian.
Okay, the next one, I think this is one of the last ones. From the presentation, it sounds like all the clients have agreed to the guardianship. What if the person won't agree and you need to go to court? What is the burden of proof besides a physician's order?
So I'm not an attorney, so I don't know that I can, I mean, what I will say is both sides. So typically the attorney for the petitioner, whomever the person is that actually filed the petition, they would present evidence showing why they believe the guardianship is necessary. And then if a client is not agreeable, yeah, it does need to go through the court process, and they would have an attorney appointed for them that would present evidence on their behalf. I will tell you, just like in most other legal proceedings, you know, there is always a goal to try and negotiate and avoid a trial process because, you know, the cost of that can be huge to a client. I've had guardianship cases that have been contested and gone to trial, and the cost of the trial has been $100,000. And unfortunately, that is paid by the individual's estate, assuming that their estate has assets to cover those costs. So there's a lot of motivation on all parties to try and negotiate things and try to be creative. And this is when we end up in a lot of situations with the limited guardianships where, you know, individuals may be willing to get some help, but they still want to have some independence. And so you can cater the guardianship a little bit towards what their wishes are, and get a little creative with them.
Okay, thank you. And then Dorothy asks, what's the average cost to obtain a state guardian?
So the Office of State Guardian, they do not actually self-petition. So if you believe a guardian needs to be appointed, they will not actually file a petition on their own and to get themselves appointed. The public guardianship offices will. So what I have seen is that unfortunately, facilities sometimes may need to actually hire an attorney, and many facilities and hospitals have, you know, an arrangement with an attorney that will file the petitions on their behalf and nominate the Office of State Guardian. And, you know, if there are assets in the client's estate, again, these are people with under $25,000, but sometimes some of those assets will be used to pay for the filing fees, and sometimes, unfortunately, the facility has to pay.
Okay, and then I've got, thank you. In the Q&A, Eleanor has a question, if you want to look.
Do spouses need to be listed as POA in order to make decisions around a person's care when they are unable to make decisions? So we talked a little bit about that, the Surrogate Act. That does allow a doctor to basically, or two doctors, to certify the individual and say they are not competent. And so we're going to designate the spouse to be their decision maker regarding medical care. And so that will work. It's a better option, I think, to have a POA document drafted and name the spouse.
Okay, and I think that, any other questions? You can type it in the chat or the Q&A. Thank you, everybody, for putting your questions out there. Let's see, so the next steps, again, once I get a list of who attended this, I will email you out the CEU evaluation. I'll also email out, once I get the evaluations back, I'll have another email with your certificate and the slides, and hopefully a link to the recording. And any questions, please reach out to me. Lauren, could you say anything about how you're available if people have questions about guardianship?
Yeah, I'm happy, and I think Claudia put my contact information in the chat box. Happy to talk to anyone if you have questions. You can either email me or call me, Claudia, if you want to maybe, or you've got Claudia's contact information, I believe, and so you can call us, and happy to talk to you.